According to the board's response to this office, the selectmen received applications from 21 people, 2 of whom requested confidentiality. According to the board's open session minutes of August 18, 2009, on page 7, the board actually received 22 applications. The open meeting law sets forth an executive session purpose to consider and interview applicants in private to ensure confidentiality under General Law, Chapter 39, Section 23B, Number 8, and that's Gerstein versus the Superintendent Search Screening Committee of Mass 465, 471, and 472 of 1989. Number 8, to consider and interview applicants for employment by a preliminary screening committee or a subcommittee appointed by a governmental body if an open meeting will have detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of a preliminary screening committee or a subcommittee appointed by a governmental body to consider and interview applicants who have passed a prior preliminary screening. General Law, Chapter 39, Section 23B, Number 8, emphasis added. Sections 23B specifically authorizes a preliminary screening committee to consider and interview applicants for employment, and to do so in executive session in circumstances properly found to have existed, unless the applicants have passed a prior preliminary screening, Gerstein, 401 Mass. Appellate 471, 472, in parentheses, one person asked for confidentiality. Thus, the board's explanation through your office on the need for privacy for employment applications is anticipated and provided for in the statute and case law. However, when hiring body wants to ensure confidentiality and privacy to applicants for employment, the hiring body may do so by appointing a separate preliminary screening committee or subcommittee. The privacy concerns do not justify any executive sessions by the hiring body itself. In order to conduct the selection process in private, the hiring body must appoint a preliminary screening committee or subcommittee under General Law, Chapter 39, Section 23B, Number 8. Only the preliminary screening committee or subcommittee may conduct the interview process in private, not the hiring body under General Law 39, Section 23B, under Number 8. The board relies upon 2 cases in discussing the need for privacy when considering job applicants, and they are Gerstein, a Mass Appellate Court, Attorney General versus School Committee of Northampton of 1978. However, in both those cases, the hiring body appointed a screening committee, again Gerstein, Attorney General versus the School Committee of Northampton. The school committee there advised 4 applicants for the position received more than 90 applications and appointed a screening committee to select candidates to be interviewed by the full school committee. The board has cited any case or any portion of the permits for hiring body to engage in executive sessions for the purpose of interviewing those job applicants. The explicit language of the statute itself restricts the use of executive sessions only for a preliminary screening committee or a subcommittee appointed by a governmental body under General Law, Chapter 39, Section 23B, under Number 8. No other executive session purpose carries this limitation, and that's under General Law, Chapter 39, Section 23B, 1, 7, 9, and 10. Every other purpose may be used by the governmental body itself. An interpretation of the statute that permits the hiring body to use an executive session under purpose number 8 would essentially excise the words by a preliminary screening committee or a subcommittee appointed by a governmental body out of the statute entirely and rendered them meaningless. The rules of statutory construction do not permit an interpretation that ignores provisions inserted by the legislature. No portion of the statutory language may be deemed superfluous. Thank you. Commonwealth versus Gove of Mass 351, 354 in 1974. When the statutory language is plain, The words must receive their usual and natural meaning. ID, quoting Commonwealth versus Thomas of 1971, Tilton versus Haverhill, and that was back to 1942. Words and phrases shall be construed according to the common and approved use of the language. Under General Law, Chapter 4, Section 6, Clause 3, thus the Board's interpretation of Purpose Number 8 that would permit a hiring body to act as a preliminary screening committee does not comport with the explicit language of the statute or the requisite interpretation of the language under the rules of statutory construction. It's a good thing this went to a lawyer. The Board has suggested that the intent of Purpose Number 8 is fulfilled even when the Board acts as the preliminary screening committee, and that such an action furthers the same purpose. Purpose Number 8 was enacted to provide a measure of privacy to the candidates who did not pass a preliminary screening by a preliminary screening committee. The statute strikes a balance between the privacy of the applicants and the right of the public to hear the hiring body's views of the candidates who may eventually become public servants within the town. If a quorum of the hiring body, or as here, the hiring body itself, is present during the screening process in executive session, the public will never hear the comments of the members of the hiring body made in executive session as to the merits or deficiencies in the finalists, applications, or their prior experience of the individual finalists. If the hiring body is permitted to conduct the process in secret, the hiring decision can essentially be made with no public oversight. A result that is explicitly prohibited by the statute's provision, this clause, capital, shall not apply to any meeting, including meetings of a preliminary screening committee or a subcommittee appointed by a governmental body, again bold, to consider and interview applicants who have passed a prior preliminary screening under General Law, Chapter 39, Section 23B for number 8, and then emphasis added, therefore, the Board's interpretation of the statute that the Board as the hiring body was permitted to engage in executive session under Purpose Number 8 is incorrect. Neither the minutes that the Board provided to this office nor the minutes obtained from the Board's website demonstrate a good faith attempt to follow the statute. Even if the Board mistakenly believed that Purpose Number 8 permitted the hiring body to meet in executive session, the Board's response states only that the Board acted as the preliminary screening committee, not that the Board appointed itself as the preliminary screening committee. The Board has not provided and has not posted any minutes demonstrating that the Board voted to appoint itself as the preliminary screening committee in open session under General Law, Chapter 39, Section 23B for number 8. Purpose Number 8 only permits a preliminary screening committee appointed by said governmental body to engage in executive sessions under General Law, Chapter 39, Section 23B for number 8. The Board's response demonstrates that the Board did not take that procedural step of appointing itself as a subcommittee, but instead just started meeting in executive session to hire the new town administrator. While one member attempted to engage in a discussion of the procedure to be used, including the topic of a subcommittee as shown in the minutes of January 6, 2009, page 7, no vote to appoint a subcommittee was taken on that date, nor was any such vote taken on August 18, 2009, the last open session before the Board began the selection process in executive session. All votes taken in open session must be recorded in the minutes exactly. General Law, Chapter 39, Section 23B, Chapter 66, Section 5A. Thus, the evidence considered in this investigation demonstrates that the Board failed to even follow the necessary procedural step of appointing a subcommittee under Purpose Number 8 in open session to alert the public of an upcoming interview process that would take place in private under General Law, Chapter 39, Section 23B for number 8. The evidence shows that the Board engaged in 6 illegal executive sessions before narrowing the field of applicants to 3 finalists. The relevant executive sessions occurred as follows. On August 25, 2009, the Board entered executive session and reduced the number of candidates to 9. Each candidate who received 3 votes would be deemed to be a finalist.